All rise. The Court of Appeals, Division 1 is now in session.
Please be seated. We're here in our case, CA CV17-0005, Westover versus Rees. Each side will have 20 minutes to present their argument. Appellant, you may save time for rebuttal if you wish. You have to keep track of our time on your own. We have a clock at the podium for that purpose. We are recording the argument, both in audio and video, so in a couple of days you'll be able to see the argument on YouTube. Because we are recording it, we would appreciate it if you would identify your client and who you are when you begin your argument so we can keep everything straight. We've read the briefs, conference the case, and discussed it quite a bit, so we're familiar with the law and the facts. So when you begin your argument, just launch right into what you think we need to know. Counsel, you may begin.
Thank you, Your Honor. Good morning, Judge Jones, Judge Howe, and Judge Morris. I'm Kevin McCarthy, and I represent Todd Westover, the appellant in this matter. I'm going to try to reserve a couple of moments for rebuttal, and I'll try to keep track of that. I have three issues that I think I would like to address during oral argument. The applicability of the statute, the Razor case, and the Eden case. Regarding the applicability of the statute, we are here because the lower court ignored Arizona Statute 12-2602 and dismissed the appellant's claim with prejudice. We're not here arguing that an expert is not needed in this matter. We assert that 2602 describes the steps defendants may take if he feels that an expert is required in a malpractice action. And according to that statute, he may motion the court for the need of an expert. If the court agrees, then the court gives the plaintiff an opportunity to identify the expert in the case. If the plaintiff doesn't comply, then the court can dismiss the plaintiff's claim without prejudice. Note, without prejudice. In this case, the appellee, the defendant, argued that an expert was needed. The court agreed, but did not follow 2602. It gave the plaintiff an opportunity to identify an expert. Instead, the court granted summary judgment and dismissed.
What's your statutory argument for saying that these things create that 2602 creates an exclusive path for which this issue to be raised? I don't read anything in the statute that says we're superseding the other provisions in Rule 56, et cetera, as a way to which a plaintiff or a defendant can raise these issues and have them resolved.
If this isn't the path by which one questions the need for an expert, then there's no need for the statute. The statute has no efficacy.
Because you can have a case in which we agree that there's other issues that preclude summary judgment. There's contested issues and material facts, so summary judgment isn't appropriate. But we want to challenge the expert alone, as opposed to saying this is the only way in which you can challenge an expert.
I apologize, Judge, but I think you're making my point. My point is that if the defendant's complaint is that there needs to be an expert to establish causation, what they do is they file a motion and demand an expert be identified or the case be dismissed. They don't motion for summary judgment because that puts the plaintiff in the position of having to gamble its case or exceed the defendant's demand for an expert. Because if the defendant says, hey, I want you to grant me motion for summary judgment in defendant's favor because this case needs an expert, and the plaintiff then, if the statute isn't the only way they can do it, then the plaintiff is stuck with either identifying an expert so the case won't be dismissed, or saying to the judge, no, I disagree. I think there's no expert is needed, in which case.
That's what 56D allows. I mean, that 56D solves that problem, doesn't it?
I don't think so, because the judge gets to weigh in. It's not the defendant's decision. It's the judge's decision whether an expert's needed or not the defendant. And if you let the defendant make a motion for summary judgment that's conclusive as to whether an expert is needed without telling the plaintiff, look, plaintiff, you need an expert in this case. You've got 90 days to get one. It doesn't serve the statute. The statute's there to give the plaintiff an opportunity to codify that experts aren't always needed, but give the defendant a path to getting an expert if they need one without jeopardizing the plaintiff's case.
Well, but counsel, if summary judgment is appropriate with or without an expert, why shouldn't the party move for summary judgment?
Because in this case, summary judgment was not appropriate with or without an expert. That's why this issue was raised. The court made
Filed for summary judgment first.
We
in this
did.
case. So
Yes.
it's not like you were blindsided and they rushed to summary judgment early on. It was in response to your motion for summary judgment.
It was, but it's not a matter of being blindsided. It's a matter of following the statute. And the statute lays out the rules under which the defendant can complain that an expert is needed in this case. And if the defendant can ignore the rule and file a motion for summary judgment, then the rule has no. Why would you ever follow the rule? Just file a motion for summary judgment.
But don't you just move? If you're faced with a motion for summary judgment and you need an expert, can't you just move under Rule 56 to delay your response while you gather information to respond to the summary judgment motion?
Yes, Your Honor, that's exactly my point. In this case, the plaintiff believed an expert was not needed, and so he's forced with either pretending an expert is needed when he's of opinion one is not needed in order to survive summary judgment versus forcing the defendant to follow the statute.
Well,
because the court decides. I'm sorry, I didn't mean to interrupt you.
If an expert wasn't needed in your view, then all he needed to do was to respond to the summary judgment request. Motion for summary judgment and just argue why summary judgment wasn't appropriate.
Well, he did respond to the motion and argue why summary judgment wasn't appropriate. But the point I'm trying to make is that the statute makes it clear that you can, if you want to dismiss the plaintiff's case, and the fact that it's dismissed without prejudice as opposed to a summary judgment where it's dismissed with prejudice is an argument why the statute should be the exclusive way to do it, because it prescribes a far lesser penalty for guessing wrong on whether an expert is needed. And I'll also point out that there's an intermediary step for the plaintiff where the court says, hey, plaintiff, you need an expert. You get 90 days to identify one, and the case goes on. If you don't, then I'm going to dismiss your case, but only without prejudice, so later you can file it. And in this case, he dismissed the case with prejudice on the basis that no expert was needed.
So you're
that an expert was needed.
This mechanism that the trial court used puts you into a untenable situation because you couldn't make both arguments. But plaintiff could have argued in the alternative. We don't think an expert's needed, and in the alternative, if we do, we'd ask for a 56D time to get one.
I think plaintiff argued in that case that an expert wasn't needed, but whether one was needed or not, he identified in the brief said that the defendant has a path if the court agrees that an expert is needed. That's the point I'm trying to make, is that the statute says if you need an expert and you don't have one, here's how the defendant forces one, and the plaintiff's case is dismissed without prejudice if an expert, if the court disagrees with the plaintiff whether an expert is needed.
But, counsel, isn't it typical for a party that's put in that position to offer their best argument against the need for an expert, but then assert that if in fact the court finds that an expert is necessary, they would ask leave to amend their pleading to obtain that expert?
Go ahead, Your Honor.
I have some history in that, and that's, to my knowledge and experience, pretty typical.
the plaintiff was pro per below, so the nuances of trial practice were probably a little bit lost on this plaintiff. But I would say that I'll add, and I know I'm hanging my hat on this, and the court obviously can disagree, but there's a statute that says shall. This is how you shall do things. And I understand that there's such a thing as motion for summons. When the legislature says you don't need an expert to have malpractice, but if you do, here's how you get one. And if you don't do what the court tells you, your case is dismissed without prejudice. And I've got a client who thought he didn't need one. The court disagreed, and instead of giving him time to get an expert and dismissing the case without prejudice, dismissed it with prejudice. That's why we're here. The court simply just had to follow the rule. And I understand there's motion practice, and 56D can have some application here, but it doesn't write the statute out of existence. Because if you can get rid of a case with prejudice in 56D, no lawyer will follow the directions in 2602. Why would you move to get a case end up being dismissed without prejudice when you can simply file a motion under 56D, and if you guess right and the plaintiff guesses wrong, the case is over?
Well, then you're going to have to now, I think, turn to Razor and tell us
of course
why Razor doesn't control.
The Razor court held, and I'm reading from the opinion, that a defendant may move for summary judgment based on a proposed expert's lack of requisite qualification under 2604 without first challenging the sufficiency of the expert affidavit under 2603. The court did not address 2602 at all in this matter. The parties, the plaintiff and the defendant agreed. They both agreed. Unlike our case where the plaintiff said no expert and the defendant said expert, in this case, both parties agreed there is an expert necessary. And in fact, they were arguing about the qualifications of the expert. That's different from what we have here. What we have here is whether an expert is needed or not. And
I don't understand how that makes a difference.
Because I'm here on behalf of a statute, 2602, and saying that's the statute that should apply in this matter, and the case should have been, the plaintiff should have been given time to identify an expert, or at worst, dismiss the claim without prejudice. In this case, in Razor, the parties agreed that an expert was needed. Completely different from what we have here. It's different facts. Number two, the case doesn't even discuss 2602, which is what I'm here about. It's all about 2603 and 2604. And let me add, I'm going to quote from the end of the case there. It says, if the court determines that expert causation on testimony is required, he has two things. Number one, if the court determines expert causation on testimony is required, and two, Ho, that's the expert in this case, is not qualified to provide it. So at the court, they told the lower court, determine that a causation expert is required, number one, and number two, that the expert identifies not qualified, it should grant summary judgment. And then it says, if it decides otherwise, that either one or two are not true, it should remand to the trial court to provide Razor the opportunity to file a 56D motion and for any other appropriate proceedings. And I'll point out again that this case is factually different. But even if we were to say this case was the same, we don't have a Razor situation here. In this situation, the lower court, yes, they determined expert causation, expert testimony was required, number one. But they didn't determine that the expert identified was not qualified to provide it. In fact, they didn't have any comment on that because the plaintiff hadn't identified one. It's just a different, it's a dog and a cat. It's two different cases, two different statutes. 2602 in my case, 2603 and 4 in their case. And even if we said, if you could wipe all that away and say that it's the same case, the court says, if A and B, then affirm. Then grant summary judgment. In this case, we don't have A and B. There was no discussion about the qualifications of the expert because we hadn't identified one yet because we didn't think one was required. And we just wanted, if the court disagreed with us, we shouldn't have to gamble our case and say, oh, we better identify an expert because if we guess wrong, our case is dismissed with prejudice. There's a statute on this. The statute says if you need an expert, if an expert's needed and the court agrees and the defendant points it out, the plaintiff gets time to identify one. That's all that's happening. So with regard to Razor, the other case that I wanted to mention was Eden versus Candelaria. That's a memorandum case that's cited by the defendant. And again, the facts are different than the case that we have here. Candelaria was the defendant. He moved for summary judgment, arguing that the plaintiff could not prove his claim without expert testimony. And then here's the important part. In the facts, they say, Eden has indicated he will not obtain an expert. That's not what happened in our case. It's a different factual case. In our case, we said we don't think an expert's needed, but we'll await the trial court's opinion on the matter, and if the court disagrees with us, we can go get one. We never refused to obtain an expert.
But you also never suggested that that was a possible outcome for you. You argued against the need for the expert and stood on that, correct? Rather than telling the judge, like I asked before.
Yes.
Can we have some latitude here, Judge? Allow us to amend if you find that we're wrong.
We did not ask for latitude, or excuse me, the plaintiff did not ask for latitude. However, the plaintiff had a right to rely on the statute that says if they were wrong, then the court's going to give me time to fix it. I don't need to ask for time because the statute gives me time. I don't need to ask the court to recognize a statute that's in existence for everybody to see. And I think that's how it differs.
Yes. And I realize it's 2602 is not exactly the same statute as 2603 and 2604, but the Supreme Court has said you don't have to follow the procedure set forth in the 2600s before filing a motion for summary judgment. So help me get around that. I realize you've tried to distinguish it, but structurally, how do we get around that?
I think structurally we get around it by identifying that the prescriptions for violations of 3 and 4 are completely different than 2602. It's a completely different situation.
What do you mean by that, the prescriptions?
Because if you violate 2603 or 2604, you don't get another bite at the apple. You don't get a case dismissed without prejudice. And that's what 2602 is why it should be followed, because it does prescribe a different remedy,
well, wouldn't that require,
a lesser remedy in terms of what the defendant wants.
But that would mean that the statute, and I'm kind of walking through this trying to follow your logic. Wouldn't that mean that the statute is less onerous for saying I don't need an expert than it is for here's my expert but the qualifications aren't as good?
I think that they're different. Whether you need an expert or not is more of a matter of I want to say it's when you have an expert and you're questioning your qualifications, the court has something to work with. The court can say, yes, you've identified an expert and I see the qualifications, but they're not good enough. You've picked the wrong guy. He can't testify to what you want to testify. In our case, it's about whether an expert exists or not. And I think that it's reasonable for a plaintiff to say, hey, this guy waited 2 years, I'm delayed for 2 years on my case, did nothing, I have to pay $40,000, I think he malpracticed. That's different than saying, I've got an expert, but I don't have a lawyer expert, they're just a paralegal. I mean, I can see the court saying, look, you've had your chance, you identified an expert, I told you you needed one, you identified one, his qualifications aren't enough, so I'm going to dismiss it, because that's his basis, that's his factual basis for trial. This is a preliminary matter about saying, as a matter of, for the case to go forward, do you have an expert or not? Yes, you do. No, you don't have one, you need to have one. And then the court says, okay, you thought you didn't? I think you do. Get one or I'm going to dismiss it without prejudice. Because the court says, even though I think you you need one and you don't, even though the court says, I think you need an expert plaintiff and you don't have one, I'm not going to destroy your case. I'm going to dismiss it, but without prejudice. So if you go find an expert, then you can always come back if you're within the statute. It's so less onerous than a motion for summary judgment, and clearly the legislature decided to provide a different path for the presence of experts.
The statute doesn't, I don't cut, but the statute doesn't prohibit filing of motion for summary judgment, does it?
It does not, but it doesn't. But it doesn't allow. I think that a motion for summary judgment has to take the statute into account. That you can't win a motion for summary judgment by ignoring the statute that says that when the defendant says, "Hey, he can't prove causation because he needs an expert," the court says, I agree with you. You need an expert plaintiff, but the statute tells me I don't grant motion for summary judgment, dismiss the claim with prejudice. I give you an opportunity to provide one. This is what the statute says. It's just not that. It's not hard. It's not onerous on either party. It's a pretty legitimate way to proceed forward. And I think there's that to the extent that they want to argue, well, you should have done it 50-60, means you have to ignore the statute. I'm going to reserve the rest of my time, if that's okay. Is that okay?
Yes.
Thank you very much.
Counsel?
May it please the court. I'm Brian Holohan. I represent the appellees. My clients are the defendants in the trial court. I need to apologize. I'm getting over a cold, so I'm going to sound kind of froggy today. Before I get into the 122602 issue, I want to address something preliminarily. Our cross motion for summary judgment in the court below made 3 arguments. The fact the plaintiff didn't have an expert was only one of them. The other 2 arguments we made were he can't prove causation. He can't prove that he lost his ability to appeal because the order he says he wanted to appeal isn't an appealable order.
And that's with or without an expert.
Exactly.
Okay.
And the trial judge ruled correctly, we believe, that it wasn't an appealable order, and that isn't even argued in the opening brief. They have seemingly waived that. The other argument we made is that even if it were somehow an appealable order, you were going to lose the appeal because what he says he wanted to argue on appeal is that there was an enforceable agreement, and the trial judge rejected that and found there wasn't an enforceable agreement, and therefore he would have lost his appeal.
Counsel, do you believe that the distinctions you're now drawing, the distinctions as a matter of law, if you will, as to the causation issue, and is that what you do you have any sense of whether or not that's what prompted the court to say, no, this is a with prejudice as opposed to without prejudice? Or are we adding that to the wrong component here is my question.
I think the trial judge made the dismissal with prejudice because he granted a motion for summary judgment. I don't think he was impressed with the distinction that Mr. Westover is now making, that under the statute it would have been without prejudice.
Did the trial court explain the basis for its ruling?
Yes, Your Honor. If you'll give me a moment.
Please.
The trial court's ruling on the motion for summary judgment is a minute entry dated September 2nd. It's docket number 18. On the first page, about 2/3 of the way down the second paragraph, the court states, the court further finds that there was never an ADD agreement that was put on the record by the parties. That's the determination that meant he would have lost his appeal even if he had an appealable order. But the trial judge went on in page 2 of the minute entry, the second full paragraph. The court notes that pursuant to Arizona Rules of Family Law Procedure 78A and 81A, that the issue of child support modification is not appealable unless the minute entry is signed. The court further finds that plaintiff Westover is technically still capable of appealing the child modification request because the 30-day time to appeal has not started. The court further finds that plaintiff's malpractice claim against defendant is legally defective because he is still able to bring that appeal, which is the underlying basis for his malpractice claim against defendant Weiss.
And that does not, those issues don't depend on having an expert testify to what the duty an attorney would have under those circumstances.
Yes, Judge. Under the objective standard of proving malpractice cases in Phillips versus Clancy, when the issue is what would have happened on the appeal, which is a causation issue and an alleged malpractice for failure to pursue an appeal, the trial court decides as a matter of law what the appellate court would have ruled had the appeal been timely prosecuted. And actually the Molliver versus Roush case says that specific thing. So here the trial judge was presented with an alternative basis to grant summary judgment, accepted it, and regardless of the correctness of his ruling on the lack of an expert, there was an alternative basis, there is an alternative basis to affirm his ruling, an alternative basis which the plaintiff hasn't challenged in his briefs.
So we cannot ascribe error to the court in denying the opportunity to obtain an expert, that in doing, denying them that ability with prejudice, it isn't a true ascription, if you will. It's apples and oranges. the without prejudice had to attach to the ruling regardless.
To put it in parlance perhaps you're more familiar with, there's an alternative basis to affirm what the trial judge did.
Okay, we can go there too.
All right, now let me take on the 122602.
And counsel, if I can, that's effectively mandated, isn't it? There's no basis at law to proceed. They have no causation. It's going to be a dismissal with prejudice.
Exactly. If they fail on any one of the elements, they lose. And in this case, the malpractice claim was you didn't appeal this minute entry, and we argued it wasn't appealable, so we couldn't have failed to have done that. You didn't lose your opportunity to appeal, but even if you had appealed, your argument that there was an enforceable agreement, you would have lost that because there wasn't an enforceable agreement. There's a transcript of the hearing. And this was all given to the trial judge, briefed and argued, and per his minute entry, he agreed with us.
Thank you.
Did you raise this in your answering brief?
Yes, it could have been done better, Judge.
I don't think you did.
Well,
Make your best case real quick that you did, because I feel like you just sandbagged this.
Beginning at about page 23, we talked about the fact that there were other arguments made. And if I'm not mistaken, this court will affirm a summary judgment if there's a basis in the record to do that. And we did make the argument in the trial court below. The problem, Judge, is I didn't write the brief.
I know, it's always unfair to...
I wrote the motion for summary judgment.
But this was a great argument, and I'm going, wow, how did I miss that in the brief? And I see that I didn't. So thank you for making me feel not crazy or admitting that it...
Yeah, well, when I read the brief, I went, what about the rest of what I argued? But it is in there. It's just not set off separately as it probably should have been.
I just looked at 23. I don't even see it. It's maybe alluded to, but...
Regardless, though, the law, as I understand it, is if there's any basis to affirm in the record, we can do that. Is that correct?
Yes, I agree with you, Judge. I beg your pardon, Judge Morse. I actually clipped it so I'd be able to tell you. It starts at page 25.
Okay. All right, you can continue. I'll
Thank you.
brush myself here.
So counsel, and let me get back on track and then take it from there. Notwithstanding the existence of the claim that the failure to assert the existence of an expert, notwithstanding that, this had to be dismissed with prejudice.
Yes.
Take it. Go
Thank
for
you. Let me add one other thought. My opponent may, when he comes back up, try to start arguing about things that happened later in the life of the case. They aren't part of the record. I don't know. I can't challenge it. But if he tries to tell you what his client did later, it wasn't presented to the trial judge. It's not part of the record in this case. All right, now let me take 122602 on. I expected them to argue that Razor was different because it dealt with 2603 instead of 2602. So I photocopied them, I set them down, and I went through them. And I found only 3 differences. They're laid out exactly the same, but there are 3 differences. Difference number 1 is 122603 uses the expression healthcare professional. 122602 uses the expression licensed professional. I think we can agree that doesn't make any difference. The next difference is that 2603, which is the one dealing with healthcare professionals, has subpart H. It's not in 2602. What 2603H says is that a claim, which is the key word in subpart A, includes a defendant who wants to name a healthcare professional as a non-party at fault. So in medical malpractice litigation, if the defendant doctor wants to say that some other doctor, not a party to the case, is a non-party at fault, they have to comply with the 2603 scheme. Again, that's a distinction I don't think makes any difference for our purposes. The third difference is the 2603F has a last sentence that isn't in 2602F. And it says, upon any allegation of insufficiency of the affidavit, referring to the expert's affidavit, the court shall allow any party a reasonable time to cure any affidavit if necessary. So in the medical context, in the Razor case, if in fact the trial judge concluded that the plaintiff's expert was not qualified, the disposition, it seems to me, should have been that under 122603F, the trial judge should have given the plaintiff an opportunity to go get a qualified expert. Now, that isn't the issue here. It wasn't he proffered a paralegal and the judge said, that's not good enough, get a lawyer. He said, I don't need an expert. And for purposes of 122602, it seems to me that the Supreme Court's determination that 122603 does not require that a defendant challenge a preliminary expert affidavit as a precondition for moving for summary judgment is exactly applicable to 122602. There's no meaningful distinction between the two statutes as far as that point is concerned. The other point that the Razor Court made, and it's what you have mentioned more than once, Judge Morse, and this is at paragraph 25. When a defendant moves for summary judgment based on a plaintiff's failure to produce an expert meeting the 122604 qualification, the plaintiff may file a Rule 56 affidavit and corresponding motion for relief. The plaintiff gambled and lost. It's that simple. He decided to stand on his I don't need an expert, and he was wrong. And the statute isn't a precondition to filing a motion for summary judgment. If he'd asked for 56D relief, perhaps he would have gotten it, but he didn't. He waited until after he lost.
He wouldn't have, because he would lose on the grounds that would not depend on an expert.
Thank you, Judge. You're right. He was going to lose anyway, but he gambled, and he lost. And the Racer case says that we didn't have to challenge his certification as a precondition to filing for summary judgment.
Why wouldn't we follow the lead that your opposing counsel pointed out over the Razor Court in remanding back to the trial court to allow him to now file a 56D?
Yeah, well, for a couple of reasons. Number one, remember that 122603F says that upon any allegation of insufficiency of the affidavit, the court shall allow any party a reasonable time to cure any affidavit if necessary. That's one. That's not mentioned in Razor, but that's one possibility.
Well, but Razor, remember, says you don't have to follow the 26.
I understand.
So I don't think that was what the court was relying on.
Yeah. The disposition part of the case begins at paragraph 31, and it begins with ordinarily in the absence of proceeding under Rule 56D, a plaintiff's failure to provide a qualified standard of care expert would justify summary judgment for the defense. So I think that's the presumptive rule. They let the Razor plaintiff, I don't want to say they let him off the hook because they remanded it to this court to decide some other legal issues that hadn't been addressed. But it does say, the reasoning was there were two judicial opinions construing the relationship between 122603 and 26.4 that were conflicting, except there's no indication that Mr. Westover was misled by the conflict that had existed between this division and Division 2 on the interplay of 2603 and 2604 on the one hand, and moving for summary judgment on the other hand. We don't know that he was confused by that. He certainly didn't say, I can't tell what I'm supposed to do. The other thing is that, remember, in Razor, the plaintiff proffered an expert, and the judge, without explaining why, granted summary judgment. The court says, perhaps you decided that the expert wasn't qualified. That didn't happen here. He didn't offer an expert at all. And then finally, in Razor, the Supreme Court noted that the trial court, quote, repeatedly indicated that it would allow Razor to use Ho as a standard of care witness. We don't have that here. So the presumptive disposition, the summary judgment should be affirmed, seems to me to apply.
Judge Morse asked you a question about wouldn't X have mandated then that it be remanded for the 56D extension and the opportunity to get an expert. But given this case, the particular attributes of this case, we're back to the point that Judge Morse said that we feel a little bit sandbagged on, that there was nothing to return to the trial court.
There was an independent basis for the grant of summary judgment that was right, hasn't been challenged, and would, I'll use the word entitled because I can't think of a better one, this court to affirm the judgment. In other words, the judge had more than one reason for granting summary judgment. The plaintiff didn't challenge two of them, and he was right, by the way. And it's in our brief, just not set out well.
Well, but I guess my point is there was a basis that could not be cured so that remand would be appropriate. They couldn't prove causation. They had no basis for causation. So a remand would have simply allowed them to hire an expert, I guess, to explain the court's order, because I don't know what else that would have
we get into the
resulted in.
Yeah. You've stated it correctly. Giving him time to get more expert wouldn't have changed the summary judgment outcome because he didn't prove causation. And according to Mulliver versus Rausch, the trial judge decides how an appeal would have come out. The trial judge decides issues from the case within a case that a trial judge would have decided. So even if you got an expert to come in and say, this was an appealable order, that opinion would be irrelevant and inadmissible because it's up to the trial judge to decide whether it was an appealable order and up to the trial judge to decide whether he would have won the appeal.
Thank you.
Are you going to write your own briefs going forward?
Well, in my defense, I was in the hospital, so.
All right. Then I
wasn't
withdraw
a
the
case of
comment,
lazy.
then I apologize.
Now you're just looking for pity, counsel.
I'll take all the help I can get. Thank you.
Hey, counsel. Counsel, rebuttal? If I might, can you explain
Yes.
why we need to decide the export issue when there are other grounds for the summary judgment that didn't depend on whether there was an export or not?
There aren't other grounds to affirm the trial court. And I understand counsel wasn't involved with the case, but I've read through the memorandum below, and there was a Track A, Track B argument that the plaintiff made in his motion for summary judgment. He said, Track A is the statute's dead. The statute is run. It's automatic malpractice. And then he had a Track B, and he said, even though the statute isn't run, this was done in like 2013, and he waited 2 years to do something about it. And everybody knows family court doesn't do things retroactively, so he committed malpractice by ignoring the fact there wasn't a signed order for 2 years. It's replete through the briefs. And his opinion, although it's not very clear in the matter, is consistent with that, because if the plaintiff's claim were legally deficient, then he didn't need to talk about an expert. The reason that he went on to talk about the expert is because he said, you've got a fatal flaw because you can still appeal. That was our Track A. And then Track B, he said, you need an expert for Track B, and I find you don't have one, and so I dismissed the case with prejudice. I'm happy to do supplemental briefing on that. I do feel a bit blindsided by it, because if it's in his brief, it's very well hidden. But my point is that the record's replete. It's the plaintiff's reply brief is all about Track A and Track B, saying that he's entitled to summary judgment even if the statute hasn't run. So the reason the court had to talk about the expert, and the reason why we're here, is because that was how he defeated plaintiff's claim on Track B that the lawyer had delayed and that delay constituted malpractice. It's clear from below the record that it was argued extensively, and we read it in the court's opinion that the reason he said an expert was needed was because that was how he defeated that part of the case. It was always Track A, Track B, and I'm happy to provide a supplemental brief to establish that to the court. We didn't come here in the face of a glaring another opportunity for the court to affirm. Does that answer your question?
Yes, it does. Thank you.
On Razor, I just want to point out again, different facts. They agreed an expert was needed. Different statute. I'll note in opposing counsel's commentary that he barely mentions 2602. He says, just read it like 2603 and 2604. The insufficiency of the affidavit, he quoted language from the statute. There was no argument about insufficiency of affidavit. There was no affidavit. The plaintiff didn't think he needed an expert, and if the court wanted one, the plaintiff could have provided one. And I want to refer again to the court's holding in Razor, paragraph 33, in which it says, if A and B are true, if Ho's not a qualified expert and the court believes an expert is needed, then dismiss. Otherwise, remand for more appropriate proceedings. So the holding doesn't really help him here.
Thank you, Counsel.
Thank you, Your
We
Honor.
appreciate your argument today.
Thank you, judges.
We'll take this matter under advisement and render our decision in due course. We stand in recess until the next case. Thank you.